Welcome back to Criminal Justice. This week we're going to finish taking a look at the courtroom and the courtroom trial procedure. This is going to lead into your last assignment, which is of course, the O.J. Simpson case, which is a culmination of basically everything we've learned this semester. But let's dig into the trial. We haven't quite made it to the trial yet. We had our arrest, we had our bail hearing, we had our preliminary or grand jury hearing, we had our arraignment. And now we're in that step between the arraignment that you've admitted guilt, or actually not admitted guilt, and the actual trial date, which is about 9 to 12 months, depending on the type of trial. Some are a little bit longer, especially something like a murder case. But this time is known as discovery. And for the prosecution, the police are going to be digging up facts and evidence and taking photographs and crime scene, DNA, all your forensics and stuff. And the defense is going to be doing the same with their own investigators. And this is where they're trying to grab as much information as they can. Also, during this time, if you're going to have a plea bargain that we talked about last week, that's going to occur as well, all during this time. So the more time that the defense attorneys have, and especially if they're a private attorney, the more resources they have, the more time that they'll be able to dig up dirt or dig up more information than maybe the prosecution knows about even. Also, during this time, we could have what's called evidentiary hearing. This can happen throughout the trial process. And when it comes to evidence, there's a guideline called the Rules of Evidence that all evidence must be presented, must be relevant, it must be important to the case, it has to be reliable, it has to be trustworthy information, and number 3, it can't be unfairly prejudicial. In other words, it can't tell just one side of the story. It has to give you, it has to be fact-based. It can't be just opinion. It can't add to that. So, fact-based. That's why in the Casey Anthony case, they couldn't say that the little girl drowned or not drowned, because that's not fact-based. That was all assumption by the medical examiners, and that's why that couldn't be presented. So the judge is, again, remember the great and powerful Oz, and they must rule on all the evidence in this case, and in that they have to decide: is it relevant? Is it reliable? Is it prejudicial? Obviously, the evidence cannot be tainted illegally. That would be a violation of the Fourth Amendment. The value of the evidence has to outweigh the prejudicial value. So sometimes the judge won't allow something to see or limit, and you'll see that in the OJ case, where they'll limit information because it's going to make the jury prejudiced towards one of the witnesses, the defendant, whatever it may be. And so they'll allow for some, but not for all of the evidence to be shown. And again, must be coming from a reliable source, not just what we call hearsay, somebody saying it's so. So that can happen, like I said, before the trial. That can actually happen during the trial as well. So now we're to the actual trial date. In the trial date, and notice I put in here some of the more famous movies that deal with the courtroom. If you're really interested in this stuff, these are some of the better movies when it comes to courtroom trials. In the criminal trial, prosecution will represent, remember, the federal or state government. They do not represent the victim. They represent everyone. Also, keep in mind that the Fifth Amendment is there to protect the accused of self-incrimination. Can't be tried twice, so those that want to get Casey Anthony again, sorry, one shot at the apple. And the right, remember, to due process. The law must be legitimate, the enforcement of the law must be legitimate, and their day in court. And then, of course, the Sixth Amendment gives the fair and speedy trial. Also, an impartial jury. The right to habeas corpus, or knowing what you're being charged with, that actually comes under the Fifth Amendment as well. The right to confront witnesses, and the right to an attorney. We remember that from Gideon versus Wainwright. Also, in this process, now we didn't really get into the jury process as much as I would have liked because of the being out. But the jury selection process, we talked about that a little bit, what goes into that. There's a lot. Runaway Jury is a great movie that shows they get on your Facebook accounts, they look at your social media, they'll look at anything that gives them an edge into what kind of person you are. In PA, 12 people are required. You may have some alternate for bigger cases in case something happens to a juror, somebody else can step in. Remember, it's called the voir dire process, where they start eliminating people based on a variety of different things. A bunch of you, I didn't finish the Bernie Getz case, I apologize. But a lot of you just went with the basic simple race. There's a lot that goes into it. Socioeconomic, gender, age. Yes, you want a jury to sympathize with your side or dislike the other side, but there's a lot that goes into this. You're going to really see this pronounced in the OJ trial, and it wasn't just based on race. So please don't always think it comes down to that. It doesn't, and you actually cannot base a jury based on race legally. That can be challenged. What's called a Batson challenge. So anyway, you could opt to have a bench trial. That is where the judge is the jury. Smaller cases will do that, DUIs, etc., misdemeanors. But typically when you get into the larger cases, people tend to have a little bit more sympathy, or you can make that argument, or it could really work against you and they don't like your client at all. And again, both sides will try to pick the juries that's best for them. As you can see, they use all kinds of stereotypes, and most attorneys will tell you that the case can be won or lost by jury selection. You can have a terrible argument, but the jury's already coming in against the defendant because they don't like bad guys, and you can win a case, and conversely, you can lose it by picking a bad jury. So now it can happen if it's argued that you cannot find an unbiased jury because of the attention of the case, whatever it may be, that they can go out of that district to find a case. A perfect example was the Bill Cosby case. The first time it went through, they actually went and got a jury from Pittsburgh because they didn't feel that the people of Montgomery County could have been unbiased in the case. That's Cosby's attorneys argued. And so they actually went somewhere else to get a jury. Another important part is the burden of proof. Remember, it goes back to the saying, the state has the burden of proving the defendant guilty. So that's where we get that term, innocent until proven guilty. The jury is to assume that that person is innocent, and it is up to the government to provide information that that person actually committed the crime. And if they fail to do so, then you have to find the defendant not guilty. And that standard is the highest that we have in any courtroom, which is, of course, beyond a reasonable doubt. Now, this term gets thrown out around a lot, and not a lot of people understand it. That does not mean 100%. 100% is pretty tough to prove. Beyond a reasonable doubt means that, basically, I'll cliff note it for you. You can go home and sleep at night knowing you got the bad guy. If you have some doubt to that, then you would have to say that they were not guilty. But, beyond a reasonable doubt does not mean 100%. There is no percentage to it. It basically comes down to, do you think this person did it? If you have a doubt, then you have to say no. But if you think they did it, then you can vote guilty. In other words, it's clear and unquestionable. You really think this person committed the crime. And why is it such a high rate? Because you're going to put this person in jail for a very long time, and it protects us from the government just coming after everybody. Gives the people a chance to make a stand. All right, once the case begins, we're going to have an opening statement. And really, unfortunately, now, if you guys have seen the movie My Cousin Vinny, that's one of the directors actually has his Juris Doctorate. He has his law degree. So a lot of it is actually very accurate to the case. Talk to mom and dad. Make sure you can see it. It is rated R. We kind of cut the scenes down a little bit in class, but the courtroom scenes are actually quite fantastic, and you'll see basically everything a lawyer shouldn't do until the very end, and he finally gets it right. But basically, the opening statement, what you're going to do, and when I say brief, some cases it can take 4 or 5 hours, bigger cases for an opening statement. But basically, you want to, this is like an English essay. Sorry to bring up English class. But this is your thesis. This is your what you believe this case is going to be about. You want to really get the jury hooked in. And when I have some of these underlying things, this is when you were doing the mock trial. Of course, you're not doing that now. But you really want to get the jury in a good story. Think of your favorite teachers that you've ever had at Methacton. And I guarantee most of them are really good storytellers. because people remember stories. And so what you want to do is you want to make really good arguments in a story version to really get your jury in on your side. And this is the first way to do it. Again, you may not have all the facts on your side, but I really like them. You're a good storyteller. And you're going to see that in the OJ case with a couple of defense witnesses as opposed to the prosecution witnesses. They're just better storytellers, and they get the jury involved, and the jury believes them more than the other side because, why? I liked them better. And so, sometimes that can be an unfair system, but unfortunately, the jury system is what we have. So you can even make arguments against the other side if you can assume what they're going to say. That's a little bit more advanced, but you can try to poke holes in the other side's case before the case begins. So both sides, prosecution and then the defense, will get to make an opening statement to the jury and make their arguments. And again, that's very much like making your thesis statement in your English essay. And then the prosecution is going to present its case. In this case, the prosecution begins the trial. They're going to bring up their witnesses. They're going to try to show those substantial facts that are going to give us beyond a reasonable doubt. Remember the body of the crime, the corpus delicti. So it's the two parts. It's the actus reus, that the defendant, the accused, had a bad action, an illegal action, and number two, that they had mens rea, what their mindset was. Depends on what you have. Remember, if it's a misdemeanor, you're going to try to prove that they acted recklessly, and of course, if it's a felony, you want to prove that they had bad intentions when they committed the crime. And remember, that's the tough part with Casey Anthony, and I am going to go back over those cases, but that was the tough part, is did she have bad intentions? And if you can argue that she drowned, then that's not bad intentions, that's an accident. But keep in mind, the most important thing, the burden of proof belongs to the prosecution. Their job is to prove both the actus reus and the mens rea to the jury so that they get in the mindset that this person absolutely did this crime that they've accused him of. Now, when you're talking to the witnesses, as you're calling them up, you're going to first start with the direct examination. Now, since the prosecution is going to start, they're going to start with their direct examination. Witness is called to the stand, and you're going to ask them questions that they've already kind of rehearsed. They already know the question and answer to. You will let your witnesses know what those questions are so they can answer them. Typically, in this case, you ask pretty general questions when it comes to a direct examination, and you let your witness just kind of tell the story. Again, storytelling, very important part of a trial. Keep your jury attentive. And so what you want to do is you want to ask them questions. Now, you're not allowed to ask what's called leading questions. That means the question's in the answer. I'll give you an example. What is your name? That's a legitimate direct examination question. If I say, is your name Patrick Smith? That's a leading question. Notice the answer's in that question. So if it's typically a yes or no question, that's a leading question. That's not allowed. You can't give your witness the answers to the question. So you have to keep it general and let them kind of tell the story. And I have, again, the rule of thumbs in here are for the mock trial that you unfortunately really won't get to do, and that's a shame. But the answer shouldn't sound rehearsed. It should, again, be a good story to tell. And then once your direct examination is done from your side, the other side will come up and ask their cross-examination questions. Now, these are just the opposite. You don't want to ask general questions here because you can do a few things. One, your witness can go off on a tangent. Two, they can answer any way you want. Biggest rule when it comes to asking questions is this very last one here. You never ask a witness a question you do not know the answer to. And I really want you to pay attention to that when you get to the OJ trial, because one of those questions in there is what sinks the prosecution. Christopher Darden, who's one of the prosecutors, will ask a question he didn't know the answer to, and it ends up coming up burning him. It's one of the biggest goofs in trial history. I mean, come on. It was publicized. It made it really bad. In this case, you do want to ask yes or no questions. You want to test the validity of the witness's testimony. Do they really know what they're talking about, or are they kind of just making up as they go along? So you want to do it as like an accusation. Did you do this? Where were you? How did you do this? What did you do? Those kind of things. So in a cross-examination, much different than a direct. I'll see you back in here in a minute.